Welcome to Office Hours, where I talk about or teach you about a subject about running a law firm, to be a better law student, be a better practitioner, and we also do LTBE. If I don't forget the segment this time, I do that like half the time. Lindsey, how you doing today?
I'm doing great. We got some laughs and some sunshine going on today.
Yes. Weather has sustained.
Yes.
Coming from year of our Lord 2025. Before we jump into it, gossipaboutprejudice.com. Please hit all the good buttons. I see you, Apple Podcasts. If you're listening to this on Apple Podcasts, which 50 to 60% of you do, leave a review if you regularly listen. I know you're out there.
Please.
Yes. Jokes aside, it does help us enormously. Show this show to someone you care about, or if you have fun or have questions, go to gossipaboutprejudice.com. We'd love to hear your stories, questions, submissions. We've been doing a lot of LTBE lately just because it's a lot of fun, but we're working on more questions to bring you. And I actually wanted to talk about, before we jump into LTBE, my office hours topic of the day, Google. Local service ads. Are you familiar with what local service ads are?
Yes, that's where when you literally just put something into Google and it shows you advertisements from local businesses, right?
Yes, they're local and Google certified. Local service ads are different than Google ads generally. The big difference is you can't optimize them. It's really, they're not targeted. They also tend to be cheaper. So it's like a shotgun. So like you kind of get what you get, but we don't use them. We don't use them because we were in a pilot program about a year and a half ago that Clio launched, and which is our practice management software. It hooks up your Clio directly to local service ads and lets you run them through the Clio interface. We were among the first law firms to do that.
Cool.
Problem, and we made frankly a ton of money off of that because there was no competition, right? There was no competition. No other real law firm was doing it in such volume. And then Clio ended the pilot program and launched the product, and then the market was swamped. And because you can't optimize, or because it's hard to bid beyond your competitors, results were too unstable, and the diminishing returns really plummeted from there. And so we left LSAs. But a lot of people use LSAs. They're a great way, particularly if you have a fantastic Google review, like star rating, like we do. We don't use them, but many firms do. The reason I'm talking about this is because Google just announced that effective, I want to say like June. Yeah, here we go. Effective June 15th, 2025, they are going to have access to all of your local service ads recordings when they call.
Oh.
Yeah, when clients call you. That's horseshit for a variety of reasons. There's huge. I just think that's bad and terrible. I think it's just to use AI, is to like train AI off of the transcripts.
Okay.
But there's huge confidentiality issues with that. And I don't think if your firm is looking at using or continuing to use LSAs, look at this very carefully, because you have until June 15th to accept the new terms and conditions of service. And if you don't, your ads will be discontinued. I would encourage you to discontinue them. We don't run them for this reason. We think the clients we get from them are terrible, but if they are working for you, just be aware that your ethics advisory may not permit you to have all of your initial intake calls recorded, particularly if they exchange sensitive or confidential information. Google is a third party. They are not bound by attorney-client confidentiality.
That's a huge deal. I hadn't heard about that.
It's an extremely niche topic.
Yes, extremely niche, but for the niche, that's massive, because that's a lot of confidential information.
A lot of confidential information
shouldn't be in Google's hands.
But I also think that like this is indicative of the direction that the tech world is taking. AI needs training data, and they've pretty much run out of easily accessible training data to be found on the internet. And so what a lot of tech companies are doing is they're finding new ways to tap into human interaction to get more of that data. These days, Meta, Instagram, and Facebook, the parent company, the Zuckbucks.
Yep.
They're selling more and more of their data to companies like OpenAI rather than to advertisers, because they have a ton of human interaction. Though ironically, dead internet theory over time says that the data that social platforms filled with bots can provide, it declines over time.
Oh yeah, for sure. Because the more bots you get, the more bots analyzing bots, and that's useless to humans.
Yeah. Garbage in, garbage in. It becomes like a death spiral, because the bots is analyzing the statistical probability of interactions of a bot based on it's like it circles the drain sort of situation.
Great.
A ChatGPT is not a chat bot. It is a word calculator. It takes a prompt, and it, based on a huge data set, it calculates the most statistical likely response, which is why its responses always sound really good but are often confidently wrong, because it's only telling you what is correct on average. Fun
Beautifully
fact.
put.
Yeah, exactly. So I just wanted to talk a little bit about that. Advertising pipelines are always best built by branding, like with our podcast amongst other projects our law firm is running. But if that's not working for you, Google ads are the next best thing because they're click through conversions. They go to your website, and your website can be completely within your control. And that's how ours find us, how our clients find us. It's fantastic. It's secure. And it is not recorded by Google. So please just keep an eye out.
There you go, folks.
Yeah. But you know what's not recorded by Google, Lindsey?
Is it bar questions?
LTBE, where Lindsey takes the bar exam, where we have Lindsey take the bar exam. Lindsey, are you ready for your first question?
Yeah, I'm ready.
Okay.
I'm ready to give it my best shot.
Here we go. So we're doing more contracts because I've just really fallen in love with contracts.
Yeah, these are fun.
This is a hard-ass question, but it's short. So here we go. Let's do a bar exam question. A debtor owed a lender $1,500. The statute of limitations barred recovery on the claim. The debtor wrote to the lender stating, I promise to pay you $500 if you extinguish the debt. The lender agreed. Is the debtor's promise to pay the lender $500 enforceable?
Oh. I don't even know. I'm assuming yes, because the lender agreed. And they said yes. And as long as two parties are agreeing on reasonable terms, then that should be permissible, right? Okay, what are my answer options here?
Sure, absolutely. A, no, because the debtor made no promise not to plead the statute of limitations as a defense. B, no, because there was no consideration for the debtor's promise. C, yes, because the debtor's promise provided a benefit to the lender. D, yes, because the debtor's promise to pay part of the barred antecedent debt needs no consideration to be enforceable.
Yeah, honestly, truthfully, I got no heckin' clue. But I'm thinking yes, that this would be valid. Can you read me again the part of the question that had the statute of limitations piece in it? Or actually, you know what? Please just read me the whole question over again.
All right, sure. It was very short. A debtor owed a lender $1,500. The statute of limitations barred recovery on the claim. The debtor wrote to the lender stating, quote, I promise to pay you $500 if you extinguish the debt. The lender agreed. Is the debtor's promise to pay the lender $500 enforceable?
Yeah, I really got no heckin' clue. But I'm going to say yes, because that feels right to me. So could you please read me C and D once more?
C, yes, because the debtor's promise provided a benefit to the lender. D, yes, because the debtor's promise to pay part of the barred antecedent debt needs no consideration to be enforceable.
Yeah, I think, whatever the heck, I'm going to guess that it doesn't need to be enforceable. Blah, blah, blah. I'm thinking it's D.
It's D?
You know what? I'm not feeling confident, folks, but I'm going to lock my answer in as D.
Locking in D?
Locking it in.
D's correct.
Yeah!
Hell
yes!
yeah. Correct. So normally in the formation of a contract, consideration of exchange is required.
Yeah.
In this case, the statute of limitations has passed. So that's a prior contract. This new agreement is, I will pay you $500 if you extinguish the debt. You'll notice there's no benefit. There's no exchange. There's actually no exchange passed between the parties because this is on a prior debt. So the promise to pay you technically isn't consideration.
Okay.
The trick here is that this is enforceable because a promise to pay a debt after the running of the applicable statute is enforceable without consideration. It's an exception. The enforcement of such a promise is a long-established exception to the requirement that there be consideration to support the enforcement of promises.
You know what? I think if I had some legal education, I probably would have gotten that one wrong.
This one, 35% of students answered it correctly.
Ooh.
But the trap answer was B,
Okay.
with 36% of students answering incorrectly. B, no, because there was no consideration for the debtor's promise.
I'm in the correct minority.
Yeah. So basically, a promise to pay a debt after the running of the applicable limit is enforceable without consideration.
Okay.
That's the takeaway.
Bing, bang, boom, folks. There you go. Hopefully you got it right, too. And if you didn't, sorry.
Lindsey, are you ready for your second question?
Whew, all right. I'm definitely going to fail this one. Let's give it a go.
Good, because I'm not. I haven't picked a question yet. Here we go. Okay, here we go. A carpenter contracted with a homeowner to remodel the homeowner's home for $10,000. The contract price to be paid on completion of the work. On May 29th, relying on his expectation that he would finish the work and have the homeowner's payment by June 1st, the carpenter contracted to buy a car under the following terms.
Uh-oh.
Ready?
Yes.
Quote, $10,000 in cash if payment is made on June 1st. If payment is made thereafter, the price is $12,000. That's the terms of the contract. With me so far?
Yes.
The carpenter completed the work according to the specifications on June 1st and demanded payment from the homeowner on that date. The homeowner, without any excuse, refused to pay. As a result, the carpenter became very excited, suffered a minor heart attack, and incurred related medical expenses of $4,000. The reasonable value of the carpenter's services in the remodeling of the homeowner's home was $13,000. In an action by the carpenter against the homeowner, which of the following should be the carpenter's measure of recovery? So this is another recovery question.
Okay.
So to reiterate, contracted to work on the homeowner's home for $10,000, relying on the fact that this work would be completed, he contracted for a car. As long as he paid on time, it would be $2,000 less. And the homeowner refused to pay and gave him a heart attack.
And that
With
cost him $4,000
in medical expenses.
Okay, got it.
Babe, wake up! New contract hypo just dropped. This is one of those fantastic hypos that's just ludicrous.
Yeah. Okay. So what are my answer options, please?
A, $10,000, the contract price.
Okay.
B, $14,000, the contract price plus $4,000 for the medical expense incurred because the homeowner refused to pay. C, $12,000, the contract price plus $2,000. The bargain that lost because the bargain that he lost because the carpenter could not pay cash for the car on June 1st. And D, $13,000, the amount the homeowner was enriched by the carpenter's service. Basically, the market value, the answer D is the market value of his work, not what he actually paid.
I see. I don't think, I'm really not sure on this one, folks, but I don't think that it's D. I don't think it's going to be based on the market value because he already did the work. So the contract would supersede any like market value assumptions, I think. So the contract, that's the 10,000. So my options was A was 10,000, B was 12.
B was 14.
B was 14 and
C was 12. Yeah.
I'm thinking it's going to be 14 because there was the 10,000 for the contract. They refused to pay him. Boom, that should be kind of plain and simple. But then refusing caused him a medical issue, which incurred these medical expenses that I guess we can assume the court has proved that wouldn't have happened otherwise, or that would be a part of that case. I'm still not feeling totally sure, but I'm significantly drawn towards B.
B?
That's what I'm thinking.
All right. Locking in B?
Let's do it. I'm locking in B.
B is incorrect.
Damn it!
B is incorrect with
Well,
20%.
50-50. I'll take
with 20% of students answering B.
Okay.
The carpenter is entitled by the contract to recover $10,000.
Okay.
But the $4,000 is not recoverable because it was not reasonably foreseen. Even if it was caused by the homeowner, which would be very difficult to establish.
Yeah.
It was not reasonably foreseeable at the time of the contract's formation.
Okay.
And I would actually criticize this question because the actual heart of the question is, quote, in any action by the carpenter against the homeowner, which of the following should be the carpenter's measure of recovery. It's actually asking you about action under the contract. It's not asking you about, I think this was poorly written. It's not really asking you about all possible recoveries. It's asking you about
the contract.
The contract. And so under the contract, even if his refusal to pay gave him a heart attack and he fell over,
the contract doesn't cover that.
You can't foresee that.
Okay.
How the fuck? It has to be reasonably attenuated, and that would be very hard to establish. So B is incorrect.
Okay, that makes good sense.
We're gonna go with I'm gonna eliminate them one by one.
Okay.
C, 12,000 is also incorrect with 27% of students answering, which is the contract price plus the $2,000 for the bargain. It's because he can't. The other contracting party can't control your financial decisions.
Yeah, those were two entirely separate incidents.
Those are separate incidents. He took on the risk of entering into another contract with a third party. It would basically mean if C was the correct answer, it would basically make anyone you were in contract with. You would make you responsible for literally anything else they did while you were in contract with them. The whole system would fall apart, right?
Not good.
So because that's like the contract was a special circumstance of which the homeowner had no notice, the homeowner had no knowledge, and it was unrelated to the work. So C is not proper recovery. And then we're down to D and A. Do you want to take one final guess to guess which one between D and A is correct?
And remind me the dollar amounts of D and A.
10,000 and 13,000.
10,000 is A.
10,000 is D.
10,000.
Actually, I'm just fucking fed you misinformation. 10,000 is A, 13,000 is D. 13,000 is the market price. 10,000 is the contract price.
I think it's the contract price. I think it's A, 10,000.
That is correct. You saved it.
Yay,
Half
okay,
credit.
my second guess.
42% of students answered $10,000 the contract price.
Okay, so not everybody. A good chunk got it right.
Yeah,
good
so,
for you guys.
So all of these other items are like unforeseeable.
Mhm.
That's
Yeah,
the heart
yeah.
of the question, is that like there has to be a foreseeability, a notice requirement for you to be held responsible for your actions. He had no idea the homeowner had no idea the contractor entered into a $10,000 contract with this other car manufacturer. He had no idea he was at risk for a heart attack. Even if he did, how could his actions influence that? $13,000 is incorrect because that's the market value of his work.
We're talking about the contract.
The contract. The law, my contracts professor always used to say, there's no boob defense. Just because you contract into a bad fucking deal doesn't make the enrichment unjust, right? Like, just because the other guy, you agreed to shit terms and the other guy's getting away with a bargain, you agreed to it. Like, the law isn't here to make you a better businessman. It's just there to enforce fairness. And so for that reason, $10,000 is the contract price. I will read you the textbook explanation and then I'll simplify it for you. Quote, the carpenter is entitled to the contract price for the work done. No surprise. The other items of damage are unrecoverable because they were unforeseeable at the time the contract was made or because they were not caused by the breach clearly enough. Though whether or not they were caused by breach, that is actually one of the things the lawyers argue over. So
sure, that was
a little bit of a
touchier.
misdirect. Yeah, but the textbook is correct that it would be very hard to prove.
That's for sure.
No unjust enrichment claim is viable in these facts because an unjust enrichment claim cannot exceed the contract price when all of the work giving rise to the claim has been done and the only remaining obligation is the payment of the contract.
Okay, beautiful.
Yeah, so
Cool.
good. This was a very hard one.
Yeah, it was hard, but it's a good learning experience for sure.
Let's do one more for today.
Ooh, okay, one more.
All right. Let's. Do you want a remedies, a formation, or a defense to enforceability?
I've always liked the word remedy. I think it's just a nice sounding and looking word. So let's go with that one.
All right, we're doing remedies.
Remedies.
Let's do a bar exam question. Lindsey, a magician contracted to hire a woman to perform as his assistant for an upcoming show. The magician promised to pay the woman $1,000 at the end.
Cool.
The magician then spent $400 renting a venue, which was non-refundable. The magician sold $2,000 worth of tickets to the show, all of which could be refunded upon cancellation of the show without the magician incurring any liability to the ticket holders. Prior to the show, the assistant informed the magician that she would not be performing. The magician could have hired a substitute assistant for $1,150, but instead decided to cancel the show and refund the tickets.
Oh.
If the magician sues the assistant for breach of contract, what damages, if any, is he likely to recover?
Ooh.
Yeah.
I don't know. Okay. I think I'm going to need to hear the answers and then the question over again, please.
Yeah, so basically, I'll summarize.
Okay.
The magician promised his assistant $1,000. He spent $400 on a non-refundable venue. The magician sold $2,000 of tickets.
So he's got 1,600.
Yep. And he could have gotten another assistant for $150 more.
Okay.
But instead, he chose to cancel the show when she didn't show up.
Okay.
Therefore, if he sued his assistant
For not showing up.
what could he recover? What should he claim? I love these. There's so much math. But ignore the math and focus on the three elements.
Yeah. How much? If he sued her for breach of contract or for not showing up, how much would he get back from her?
Yep.
So I want to make sure I understand the math just a little bit. So what was that about the tickets being refunded? He needed to.
The venue is non-refundable, but the tickets were.
Okay.
Is
so
the
he's
question.
out $400.
He's just
total.
out $400. Yeah.
Okay. All right. Huh. So would he be able to get back from her 400 or 1,000? That's what I'm thinking.
I'll read you the answers.
Okay,
So
okay.
here, A, $600, the profit the magician would have made under the original contract. B, $400, the magician's reliance damages for renting the venue. C, $150, the difference between the contract price and the cost of hiring a substitute assistant. And D, the magician may not recover any damages because he failed to mitigate.
Oh, that might be the case. Failed to mitigate. That's got some interesting implications there. Ugh. So I don't know what mitigation, technically speaking, would mean in this instance. Can you read me answer D one more time, please?
Sure. Answer D.
Mhm.
The magician may not recover any damages because he failed to mitigate.
Failed to mitigate. I'm thinking that that's the case because he's the one who chose to pay a non-refundable deposit, and her performance or lack of had nothing to do with the fact that he paid that deposit. That's like a separate contract. So I'm thinking if he can get anything back, it's $400, but I'm thinking he can't. I like D. I'm thinking that he didn't successfully mitigate. So I think I'm going to lock it in. I'm going to lock in D.
Locking in D?
Yeah.
All right. With 41% of students answering D, that is incorrect.
Damn it!
That is incorrect.
Ooh.
That was the trap.
Yep,
that was
I got
that was the
trapped.
trap. This was also another hard one. Only 38. The answer is C, $150.
Okay, wow. I was entirely on the wrong tracks.
The difference between the contract price and the cost of hiring a substitute assistant. So the trap here was thinking that he failed to mitigate the situation.
Yeah, that was his fault.
Mitigation is a concept which is to say, if you are injured, you have to do what you can to minimize the damage to yourself, right? What you like, for example, if you're hit by a truck and then you fail to get medical treatment and then your injuries are far more severe and long lasting than they could have been, you can't sue. You can't sue for like your
bad
stupidity.
Yeah, okay.
You can't sue for that whole thing. You can only sue for what might have happened had you been diligent in your treatment.
Okay.
That's why the first thing when you go to a personal injury attorney, the first thing they ask is go to the doctor, get treatment. Go, we
Don't
need
screw
you in a
yourself
fixed and stable position first. Go get every piece of treatment you need to be healthy again. Here, the magician, there was a substitute available for $1,150.
I see.
And so
the opportunity was there, and so he, I get it.
And so he chose, to forgo the whole thing, and that's his choice.
Okay.
Additionally, the really complicated technical issue is this is called expectation damages. They're based on an injured party's interest in having the benefit of the bargain executed. Typically, expectation damages are equal to 1, the value of the performance that should have been rendered, 2, plus any incidental or recoverable consequential damages, less 3, any costs the injured party saved or reasonably could have been saved by not having performed under the contract. Here, he can't really mitigate this because it's the only difference between the situation is whether his assistant shows up. Like, how are you supposed to mitigate that?
Yeah, that's out of his control.
And so he can sue for $150.
That is like almost a useless amount of money.
Yeah, almost a useless amount of money. Well, I mean, that's what you get in these. These are all tiny amounts of money, legally speaking.
These hypotheticals.
So answer C is correct.
Okay, well, damn it. But you know what? I like the answer.
In
the end.
I'll leave you with a quote.
Okay.
If an injured party could have reasonably avoided a loss but did not mitigate his losses, a court will estimate the position the injured party would have been in had he mitigated and subtract the amount the third portion of the expectation damages calculation. If an injured party does take steps to mitigate his losses, then any losses actually avoided will be deducted from the amount expectation of damages.
Okay.
So this speaks to the civil system. The civil system's purpose is not to punish, it's to return. It's to bring you back to where you would have been had everything gone as planned or hadn't happened.
I see. And so the court's ruling there is that it's on you almost had the opportunity to do this. You would have just incurred this one more little cost by changing this one thing. And so that little cost is all you're owed in the end.
And I'll also say, $600, the profit the magician would have made, not relevant to the contract.
Yeah, no, that's not
That's
relevant.
a business decision.
That's the end.
Yeah,
the court doesn't care about what happens afterwards.
Exactly. So that has been LTBE this week. Everybody, please push all the good buttons. Leave us a review on the platform. Show this work to someone who would care about it or love what we do here.
Or hate it, actually.
Actually, honestly, send this to your ops. Send this to the worst people you know.
Thank you.
Yeah, but get them to watch regularly. We will be thankful. LTBE is sponsored by Quimbee Bar Prep, where they need CLEs, question banks, long answer questions. Quimbee's got you covered. Also, thank you to Hemmat Law, our primary sponsor. Go to hemmatlaw.com/GWP and also go to gossip.prejudice.com. Submit questions, comments, stories. Listen to the podcast on all platforms, and thank you so much.
Thank you. Bye.